All right, welcome to the Legal Lounge here on CRN Digital Talk Radio, streaming live coast to coast and around the world on crntalk.com. Also available in stunning high-definition video on facebook.com/CRN Talk, on tikilive.com, and of course on CRN's custom-built Roku channel. Also, you can find us directly on crntalk.com. I am joined, as always, by the one and the only, an active attorney, U.S. Army veteran, Juris Doctorate in Law, undergraduate degree in physics, and author of a book that has proven to be a guideline for the Supreme Court now and in the future. That book, America, the Illusion of Freedom, is available on Amazon.com, Barnes & Noble, and on iTunes. Once again, that fantastic book, America, an Illusion of Freedom, is available wherever you find your books. It's the show you get the news nowhere else. Richard, how are you?
I'm very good. I'm not so happy to hear that some of our guys got it. I have a feeling, though, that this is going to be the linchpin, if you will, to get Trump to get really, really, really serious about just ending this charade that we have. Some people would call it a charade because we haven't really, really put Iran where it belongs.
Of course, we're talking about, sadly, yes. Central Command revealed today that two United States service members were killed in a ballistic missile attack in Jordan from the Iranian regime, and I will be definitely monitoring that situation moving forward.
Absolutely.
It seems that conflict is once again upon us, and we will definitely be monitoring that moving forward. Of course, this is kind of like a part two of what we talked about last week extensively about the birthright citizenship case, what I call Trump via Barbara. And
yes.
This was a case, of course, that we've been following extensively, that Richard has written about extensively in his book, even before this case came to our attention. And this has to do with the injunction that, not the injunction, the executive order that Mr. Trump wrote and signed his first day in office of his second term, saying that he wanted to eliminate birthright citizenship. Several injunctions by the lower courts stopped that order from going into effect. And the Supreme Court did hear that case and decided that the birthright citizenship stays where it pretty much is.
Yes. Well, the thing is this, that we almost have to start because people have, this has created a lot of controversy. And I know, Mike, you mentioned it, and I've also had people call me and say, Richard, I hear you guys, but I wonder, could you give us a fast review of it? Because we're not lawyers. We don't quite really understand what's happening. So I'm just going to start, Mike, with the 14th Amendment. I'm sorry.
Hold your fire on that. We're right up against the break right now.
Yeah, okay.
We kind of wanted to set the table here a little bit, but we're going to really get into this again. And like Richard says, you and I have gotten a lot of calls, faxes, emails, and notes regarding this case and our opinions thereof and some of the rationales behind the court's arguments.
And it deserves this attention, quite frankly.
Oh, very well. Yes, absolutely. Stick around, you guys. Once again, check out that fantastic book, which we're going to be quoting from today. Richard's fantastic book, America, an Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. Stay with us.
Do you have trouble getting in and out of the bathtub? Are you afraid you'll slip and fall entering or exiting a tub? SafeStep walk-in tubs can transform your bathtub from an area of concern to a calming refuge. Call them today at 1-800-561-6320 and save $1,600. SafeStep walk-in tubs and showers are proudly made in Tennessee and offer an ultra-low step-in, avoiding that difficult climb over a traditional bathtub wall. They also offer a variety of therapeutic benefits that may help soothe your aching muscles and joints, increasing your mobility, boosting your energy, and improving your sleep. SafeStep walk-in tubs are designed to easily fit your existing tub space and are often installed in as little as one day. Just dial 1-800-561-6320 today to save $1,600 and receive a free shower package. That's 1-800-561-6320 for a free no-obligation consultation and to save $1,600. SafeStep walk-in tubs. Safety never felt so good.
Okay, we are back. Thank you so much for joining us. As always, all past and previous sessions, including last week's part 1 of our Birthright Citizenship Extravaganza here on the Legal Lounge, Richard Nixon Live. It's available on Facebook. You can find that on Richard's Facebook. Just search Richard A. Nixon on Facebook. You can find it on CRN's Facebook. Search for CRN Digital Talk on Facebook. Or you can find us on YouTube or Rumble. Search for CRN Digital Talk on both those platforms. And our complete archives there as well. All right, Richard, so we're setting the table here talking about the Birthright Citizenship.
Yes.
The executive order was signed January 20th, 2025. Then the injunction started flying. And incidentally enough, too, this birthright citizenship case actually led to a different decision by the Supreme Court, not about the merits, but about nationwide injunctions to begin with. But the original injunction that we're talking about, where a court, I believe the first court to do it was up in the Seattle, Washington area, says you can't do it.
Right. And
perhaps the court looked at that injunction in a different way. Things might be a lot different, right?
Oh, absolutely. So, Mike, I don't know if we want to start with mentioning the 14th Amendment and its text now, or should we just start off with the injunction?
Let's just start with the injunction.
Okay, very good. So I believe this is Kavanaugh's dissent. He said basically that the respondents claim, now the respondent are the people, Mr. President Trump issued an executive order basically saying that if the mother was here temporarily or illegally, and the father was neither a citizen nor a legal permanent resident, that child would not be a citizen. Now, the other people, certain people challenged that EO, and this is what happened. They're called the respondents in this case. The respondents' claim in this case is that Executive Order 14160, that's Trump's executive order, was unconstitutional on its face. Now, those 3 words, on its face, is very important. The case goes on to say, to prevail on this facial claim, they must show that no set of circumstances exist under which his executive order would be valid. Now, they cite a case, a U.S. Supreme Court case, U.S. versus Salerno, 1987. Now, the reason that this dissent is critical and very, very accurate and important is the following. El Salvador happens to be a country whose constitution basically says that children of a Salvadoran father or mother born in a foreign country are Salvadorians by birth, which means mom and dad from El Salvador come to this country or any other country. The baby is born here. Let's just assume they come here and the baby's born here. Under their law, El Salvadoran constitutional law, that child is a Salvadorian, not a U.S. citizen. And this is squarely in sync with Trump's EO, which says the same thing, that if you come here either temporarily or illegally and you have a child here, if the parents are not citizens or permanent legal residents, the child is not a citizen. That squares with. That is to say, El Salvadorian law says the child is not a citizen of the U.S., and Trump's EO says that child is not a citizen of the U.S., which means, in short, that this so-called unconstitutional injunction on its face had to fail. That is to say, that injunction should never have been granted against Trump in the first place. Trump's EO was in fact correct, and it should have been going forward since the trial court.
The logic there being that if we have El Salvador, and it's not just El Salvador, there's several other countries. Many other countries have that same. And then we see, how's that relate? How do those connect that to the executive order?
Well, again, the executive order basically says that if you just come here illegally or come here just temporarily and have a child here, that child is not a citizen unless the father is a citizen or a permanent legal resident. Well, in the El Salvador factual pattern, they did come here, whether they come here temporarily or just illegally crossing the border with a visa or whatever. The point is the father is clearly not a citizen of the U.S. or permanent legal resident. They are citizens of El Salvador. Given that factual pattern, Trump's EO would be valid. Therefore, any injunction against his EO would have to be unfounded, and therefore Trump should have won before the trial court in the first place, and we should be obeying the law as dictated by Trump's EO right now.
It shouldn't even gotten to the Supreme Court.
Absolutely.
At the trial court level, at the injunction level, that injunction should have failed on constitutional claims.
Exactly. Now, the question is, what do we do now? Now, Trump has already filed papers basically asking for a review, and it's not unlike a higher court like the Supreme Court to look back to see that the trial court or the appellate court made a decision, made an error, I should say, in law, and to remand, that's the word remand, to send it back and consider exactly what the Supreme Court's ruling was. For instance, the Supreme Court might say, upon further review, we believe that the injunction against Mr. Trump should not have been granted, and we send this back to the trial court for them to act consistent with our ruling. So it could be fixed. We wouldn't have to do an amendment or even have Congress do anything. Trump's people could just ask them for a review, which they already have.
And thank you for bringing that point up, Richard, because a lot of people, my liberal brothers and sisters out there who, I like, even though they're wrong a lot.
Yes.
They're like, oh, it's over, it's done. And then I'm like, well, there is, and you brought this to our attention, so I put my crack research staff on this.
Yes.
That under the Supreme Court rule, under rule of the Federal Procedure number 44,
yes,
the respondents to this, in this particular case, President Trump, have 25 days to actually petition the Supreme Court for a rehearing. It's extremely rare. The last time that this has happened, where a Supreme Court ruling has been reheard under said Rule 44, was in 1965. It was a PI case out of Maryland and Maryland v. U.S.
Yes.
But there is precedent that this has happened before, where a Supreme Court...
Oh, absolutely. Because, again, imagine the Supreme Court in this dilemma that they now find out, hopefully they just recently found out through Kavanaugh's dissent, that, wait a minute, there are situations under which his EO would have been proper, that an injunction against it would have been improper, and therefore the court has to feel that it must correct this error. So I'm hopeful that the court will look at it again. They don't want to, of course, blame themselves for this error. The problem actually lay with the trial court having granted an injunction improperly, and that has to be corrected.
All right. We're going to talk more about this, of course, right after the break. And we're going to get into the 14th Amendment, the language itself. Richard teased this. He's written extensively about this in his book, American Illusion of Freedom, Chapter 7 specifically. And we're going to talk about that and also vis-a-vis the rules of construction. So stick around, you guys. We'll be right back. Once again, you're listening to The Legal Lounge. Richard Nixon Live. As always, all past and previous sessions are available on YouTube, Rumble, and Facebook. Search for Sierra Digital Talk on both those platforms. We'll be right back. Stay with us.
That's the ease at which you get information. You want it, you get it, like that. Ask your phone, group chat, smartphone. You're always connected and informed in real time, no waiting. So if you're diabetic and still using finger sticks to read your blood sugar, what are you waiting for? Knowing your blood sugar levels instantly is important for managing diabetes. Call US Med at 888-665-0596. To learn more about continuous glucose monitors, a real-time instant method to track your blood glucose, US Med is an approved provider for Medicare and over 1,000 private insurers. And the best part? Call 888-665-0596 and we'll give you a free insurance benefits check today. So call 888-665-0596 today. That's 888-665-0596. And manage your diabetes as easy as...
Savor the past and savor the glory days of Las Vegas. Enjoy 70 years of true Las Vegas history as 4 generations of family wait to greet you at the legendary Bootlegger Italian Bistro. Wine, dine, and experience Mama Maria's award-winning original recipes while surrounded by original family photos and celebrity memorabilia. Enjoy piano artistry nightly with music from the Great American Songbook in our main formal dining room. The Bootlegger Italian Bistro, 7700 Las Vegas Boulevard South, in the entertainment capital of the world. The Bootlegger Italian Bistro, open 7 days a week. 7700 Las Vegas Boulevard South, in the entertainment capital of the world. It's Vegas, baby.
What do you call charging thousands of dollars for hearing aids? At MD Hearing, we call it outrageous, because hearing should not be a privilege for the rich. It's a basic need everyone deserves. Hi, I'm Dr. Sandra Porps, head of audiology at MD Hearing. If you or a loved one have trouble hearing but don't want to waste thousands for a hearing aid, MD Hearing was created for you by doctors and audiologists. A high-quality, FDA-registered hearing aid for a fraction of the price. No costly doctor visits, no expensive and time-consuming fittings, no bulky, old-fashioned hearing aids that cost thousands. The MD Hearing Neo is just $297 per pair. It's rechargeable and fits discreetly in your ear. Even better, it lets you hear what you've been missing at a savings of more than 90% off the average price of a traditional hearing aid.
Try MD Hearing risk-free for 45 days by calling 800-969-0121. Plus, you'll get free shipping. Call now, 800-969-0121. That's 800-969-0121.
Okay, we are back at the Legal Lounge. Thank you so much for joining us. We're having part 2 of our special here on the birthright citizenship decision, Trump v. Barbara. Quite the decision. And all this rests on the 14th Amendment and what it means, the language there within. Richard, and you've written extensively about that, specifically in your book, American Illusion of Freedom, Chapter 7. And let's talk about that. What did the drafter intend for the 14th Amendment, specifically the Citizenship Clause? Let's go down, break that down.
Thank you, Mike. The 14th Amendment was from 1868. It was just after the Civil War. At that time, there were 3 Civil War, if you will, Civil War amendments that were enacted, the 13th, 14th, and 15th. The 13th Amendment basically said, no more slavery in this country, period. Slavery is over. The 15th Amendment said all citizens now can vote, including those who were previously members of the slave class.
Just real. I'm sorry to jump in real fast, Richard. I have to. That was my
previous conditions of servitude.
But all male citizens can vote.
Does it say all male citizens?
Well, because we didn't get women's suffrage till I think.
I'm talking about the 15th Amendment, though. It doesn't say male.
Okay.
Okay. Now, so we get those 2 down. Now we get to the 14th Amendment, and right off the bat, the first thing it says is all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, here's the point. If you do as the left has been doing, and those on the wrong side of this issue, if you will, have been doing, is to say that, well, if you're born here, of course you're subject to our jurisdiction and our rules, and therefore they mean the same thing. Well, the truth of the matter, that is a misinterpretation of how this and subject to the jurisdiction should have been and should be interpreted. Let me just go on for one more paragraph, Please. As I say in this world-famous article that I wrote to the Daily Journal, I'm not sure it's going to be printed yet, but those who interpret the above by equating being born in the United States to and subject to the jurisdiction thereof, they are in violation of a very basic rule of construction, namely the rule against surplusage. Now, this rule is not something I made up. It is a rule now that has been okayed and verified and justified by the Supreme Court in previous decisions.
These rules are fundamental to American jurisprudence.
Absolutely. And they tell us literally how judges, judicial officers, how they should interpret the law. Now, here's the point. If it is a violation of the rule against surplusage, that means that different words in the same document cannot have the same meaning. Now let's try that again. Different words in the same document cannot have the same meaning. So that what we're saying is, if in one part of the document we're using the word A, and in another part we're using the word B, A and B cannot possibly mean the same thing. So, and if they do, if different words do have the same meaning, then one is redundant. So if A and B really mean the same thing, then we don't need A or B. One of them is redundant, unnecessary. Now, the significance of that is this. This redundancy is to be avoided. Now, remember, this is from the standpoint of a judge reading something that someone else, like Congress, has written. This redundancy is to be avoided as it renders a part of the document meaningless, and it is assumed that this was not intended by the drafter. Fine. Hence, the meaning of "and subject to the jurisdiction thereof" cannot mean the same thing as being born here, and therefore we must now search to find out what it actually does or did mean. This is where we have to go to history, and we'll go on after that.
Let's talk about Chapter 7 of your book.
Yes.
What Senator Howard, because the citizenship clause of the 14th Amendment is somewhat based upon the Civil Rights Act of 1866. Senator Howard wrote that particular piece of legislation. And there's some differences in the language between the Civil Rights Act of 1866 and the Citizenship Clause of the 14th Amendment. But I before we get into that, I just briefly want to, what you just talked about, the rules of construction, why that's so important.
Yes.
Because those canons of construction are what you said, and I just want to reiterate that these are what judges, specifically appellate judges, and the Supreme Court justices are appellate judges, that's what they should look to, because they're looking to the text of a statute to interpret that statute. And so when they do not follow those rules of construction, and I would posit, Richard, that perhaps certain members of the court, looking at you, Chief Justice John Roberts,
yes,
it's like writing a book. They wrote the ending first and then found a way to get there.
Exactly. And just to clarify just a bit more, in a little more detail than I may have just recently said, this is written from the standpoint of a judicial officer, whether he be a trial court judge, appellate court judge, the Supreme Court, whoever, I should say. Our fundamental task in construing a statute, which applies to the Constitution and propositions as well, is to ascertain the legislative intent. Okay, now why do we care what the legislative intent is or was? So as to effectuate the purpose of the law. That is the point. That is what a judge is supposed to do. Figure out what the law means, and the way we go after that is to figure out what the legislative intent was. Let me say that again. Our fundamental task in construing a statute or a constitutional provision or a propositional term is to ascertain the legislative intent so as to effectuate the purpose of the law. Now, because the statutory language ordinarily is the most reliable indicator of legislative intent, we begin by examining the words of the statute. Now, I pause here for a minute because one of the things that Justice Thomas, in his dissent, called out, which is 1,000% correct, is Chief Justice Roberts and Miss Barrett did not even put any analysis to the text of the 14th Amendment. They jumped immediately to the Wong Kim Ark case, kind of adopted their analysis of it, which was nothing but a declaration. They never did what is necessary under the law for a judicial officer to do. You have to look at the words of the text of the statute, in this case, the 14th Amendment. They failed to do so.
They failed to do that, and also you have to, as you just said too, if the text is ambiguous, you need to discern the legislature's, the drafter's intent.
Exactly.
And having the 13th and 14th and 15th Amendments solely dealing with the end of slavery and what to do with those freed slaves, it seems pretty obvious to me as a layman, Richard, that the intent of the legislature was to grant citizenship to freed slaves, not those born on just because they're born on U.S. soil. Stick around. We'll be right back. Stay with us.
Better than a great conversation. How about a great conversation paired with unforgettable cheese? At Harmony Cheese, we don't just make cheese, we craft moments. Wisconsin-made, rich, creamy, bursting with flavor. Our cheeses turn any gathering into a celebration. Whether it's our fan favorite cheddar or our bold new 6-pepper cheese, every bite is a harmony of taste and tradition. And now, CRN Talk listeners get an exclusive treat, 10% off your first order at harmonycheese.com with the code CRN Talk. That's CRN Talk. Don't wait. Stock your fridge. Impress your friends. Just treat yourself. Our new gift boxes are the perfect way to say I care without saying a word. Wrapped, ready, and guaranteed to wow. harmonycheese.com. Taste the conversation, share the love. That's harmonycheese.com. Say CRN Talk.
Every 40 seconds, a child is reported missing. That's 2,000 children every single day. It's a heart-wrenching reality that we can no longer ignore. Find the Children is a nonprofit organization dedicated to helping find missing kids. You can be a part of their mission by donating your unwanted vehicle, running or not. Call 1-800-581-7933. We guarantee that you will receive the maximum tax deduction. We provide fast, free pickup with 24-hour response. Call 1-800-581-7933. Find the Children provides crucial resources to help find missing children and educational materials to teach kids how to recognize and avoid predators. Our recovery programs have a proven track record of reuniting kids with their families. It's time to act. Donate your unwanted or unused car. Help us build a world where every child is safe. Pick up the phone and call 1-800-581-7933. Together, we can bring these kids home safely. This advertisement was paid for in partnership with Cars R Us and Find the Children.
Okay, we are back in the Legal Lounge. Thank you so much for joining us. We really appreciate it. As always, you can check out Richard's fantastic book, which he's been quoting extensively from, America, an Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. All right, Richard, let's talk more about interpretation. And you wanted to mention something about Senator Howard's language, correct?
Yes. Well, once we get to the fork in the road, as someone used to say some years ago, take it. Well, we're into the fork of the road. We're arguing, if you will, about what does and subject to the jurisdiction thereof actually mean. And we've already mentioned the fact that as far as we are concerned, I am concerned, and this show and many, many people on the right is concerned, they do not mean the same thing. Now, when you get into this kind of a dilemma, we could argue that, therefore, that the language is ambiguous. Now, when the language is ambiguous, in other words, what does and subject to the jurisdiction thereof mean, we may consider it a variety. Now, this is from the standpoint of the officer, the judicial officer. He may consider a variety of extrinsic aids, including the purpose of the statute, legislative history, and public policy. Now, this is where it forces us now to go to 1868 to look up, if we can, find out who actually wrote the 14th Amendment Citizenship Clause. And what we find out, Mike, if I may proceed,
Please.
In order to understand this and subject to the jurisdiction thereof clause, we have to refer to history. And as cited in my book, America, an Illusion of Freedom, the author of the 14th Amendment Section 1 Citizenship Clause was Senator Jacob M. Howard of Michigan. Senator Howard described the clause. Now remember, it starts off by saying all persons, but Senator Howard's rendition is it describes the clause as excluding certain people. They exclude American Indians who maintain their tribal ties. Now again, this is not an anti-American idea that we're excluding Indians, except that the Indians, if they are born on in their tribal territory, they owe allegiance to their tribe, not to the United States. So it's not intended to be in any way racial or
It's because the Native Americans wanted that. They wanted tribal sovereignty.
Now, to include American Indians who maintain their tribal ties and persons born in the United States who are of foreigners or aliens. Now, that's the point. That's the group that Mr. Trump was trying to pinpoint here, that if the parents are here as foreigners or aliens, and they have a child here, under the writer of the 14th Amendment Citizenship Clause, according to his writings, these people are not born as U.S. citizens, and that should resolve the issue. However, if those of you are not satisfied yet, we go to 1872 to the Slaughterhouse case. Slaughterhouse case said the same thing. We intend to exclude from its operation children or citizens of subjects of foreign states born with. In other words, if you're born here, you do not owe allegiance or loyalty to this country. Your child being born is not a citizen. At least that's what was intended.
Okay, so just real fast. The Slaughterhouse case, 1873, which you also read extensively in your fantastic book. This is the Supreme Court's first interpretation of the 14th Amendment, and that court held that that citizenship clause excludes certain people born in the United States, including children of foreign diplomats, children of foreign ministers or consuls, and most importantly for our purposes here, certain other owing allegiance to another sovereign.
Okay. Now, what about, did you mention the Elk versus Wilkins case?
Please.
Okay, very good.
There you go.
Elk versus Wilkins, 1884. This was a case about an American Indian who was born on his reservation. He wanted to vote because under the 15th Amendment, 1870, it permitted citizens to do so. And he thought, or at least he argued that he was a citizen. Now, the United States Supreme Court held that the words, and subject to the jurisdiction thereof, meant persons born here who were not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject to their political jurisdiction and owing them direct and immediate allegiance. Hence, by applying the same criteria as provided by Senator Howard, the court held that he was not a citizen because he owed allegiance or loyalty to his tribe and not to the United States. Now, this is not to be looked at as a pejorative or any kind of negative slant on Mr. Elk, the Indian. He was advised to go ahead and bring a naturalization process. He could easily be granted citizenship by the naturalization process, and that's, I think, what he actually did. And there is a third case called the Wong Kim Ark case, which the Supreme Court, at least the majority, seemed to use as their model, which we'll go into in a minute, has nothing to do with Trump's EO.
Justice Thomas agrees with you in his dissent as well, because his reading of the Slaughterhouse case as well as Elk versus Wilkins, and he talks about subject to the jurisdiction there. Well, and even before that, let's just back up. Going back to rules of construction and just reading in statutory interpretation, they wrote in the 14th Amendment, what they could have wrote, Richard, if they just could have said anybody born in the United States is a United States citizen. They could have said that.
Correct.
But they didn't say that.
That's right. And you see, that's why it's such an egregious mistake, because everyone knows, even guys who graduated from Harvard, which is probably the majority of our Supreme Court, know that you cannot just ignore a word in any kind of legal type document, whether it be a statute, a constitution, or a proposition. You must give meaning to every single word. Otherwise, what are you saying to the drafter? You're saying, what are you including unnecessary words in your writings for? Every word has to be considered and figured out what its meaning is. That is, everybody knows that's gone through at least 20 minutes of constitutional law in school knows that.
And this is something that this kind of interpretation of statute language, especially when it comes to the Constitution itself, this is something the court does all the time and has recently done most in Brune.
Yes, and that's exactly what Justice Thomas says. These guys didn't even do a textual analysis of the 14th Amendment. They immediately jumped to Wong Kim Ark, which really doesn't say what they wanted it to say, but they twisted that around too so they could use that as some authority for their position.
Just within the last couple of years, the court ruled that there is a constitutional right for to carry a firearm, because they looked at the Constitution and it said to keep and bear arms.
Yes.
The founders, the framers, put that in there, keep and bear arms on purpose.
Exactly.
To keep, have, possess, but also bear, meaning to bear arms in public for self-protection and protection of one's loved ones.
Exactly.
And for the court to go one way with the Second Amendment case, but a different way with the 14th Amendment using the same statutory logic that's not congruent is upsetting. Stick around. We're going to talk more about that Wong Kim Ark case, which Richard, I think, really cracks the code on right after the break. Stay with us.
sell my house fast. And we've been buying unwanted houses for cash fast for 25 years. We buy old houses, new houses, abandoned houses, all types of houses. And we'll buy your unwanted house for cash fast. If you're relocating, inherited a home you don't want, if you've got a tenant you really don't want, Sell My House Fast will buy it fast. If you're behind on taxes, want to avoid foreclosure, if you're going through a divorce or just need cash fast, we'll buy your house at a fair cash price, and we'll close fast too. Sell with us, and there's no real estate agent, which means no real estate commissions. We'll do all the repairs, all the cleaning, and cleanup. We've got hundreds of Google 5-star reviews because our offers are fair and the process transparent. Call now to connect with a qualified local buyer. Call 1-800-743-0546. 1-800-743-0546. 1-800-743-0546.
When you really want Italian food, you've got to go to Columbo's. Columbo's Italian Steakhouse, Colorado Boulevard, Eagle Rock, because it really is that little neighborhood place you wish was down the street from you. Here's to spring. As the flowers bloom and the birds sing, that beckon us to Good Time Central, it's a Columbo's thing. Any season is a delicious reason to devour a delicious steak that's also pleasing. Or pamper your palate with Columbo's family Italian specialties. And another reason? The freshest fish offerings meant to enthrall, and the world's greatest meatballs, renowned by one and extolled by all. Columbo's, an easy, affordable, and delicious flight from the same old, same old. Columbo's, mangia bene.
And we are back. Thank you so much for spending some time with us. We really appreciate it. And as always, make sure to check out Richard's fantastic book, American Illusion of Freedom. You can also follow him on Facebook, Richard A. Nixon. All right, Richard, Wong Kim Ark, this is the case that you've written about in that said book. Very interestingly, you've really kind of cracked the code on this. This is something that Sauer argued as well.
Yeah.
But before we get into like the kind of real highly technical legal stuff, which you're expert at, I just want to let the audience know the difference between Wong Kim Ark and what we're seeing now.
Yes, go ahead.
Wong Kim Ark, and Richard, correct me if I'm wrong, they were a Chinese couple living in the San Francisco area. They were law-abiding citizens.
Right.
However, they were not able to retain citizenship, United States citizenship, technically because of a treaty between China and the United States.
Correct.
Upon penalty of death back in China.
Yes.
That is a far cry from someone crossing the border illegally, having a baby, and then that child automatically becoming a United States citizen.
Yes, and they were permanent legal citizens. That is to say, they were here with our knowledge and consent. I guess you'd call them green card holders. I like to call them as de facto citizens because they did all they could to be citizens, but because of a treaty, they were not permitted to do so. Now, the parents were not technically not citizens, and because of a U.S. treaty, they were not allowed to become a citizen. As you said, under penalty, a severe penalty of death, if the Chinese found out that these people were now American citizens. Anyway, the Chinese parents were therefore prevented by law to become citizens. However, as they were permanent legal residents, they had satisfied the criteria of loyalty and allegiance to this country sufficient for the court to hold that their child was a citizen. Hence, the dispositive issue in determining whether a child born in the United States is a citizen is the allegiance or loyalty of its parents due to their domicile in the United States for such a lengthy time. Now, if you don't mind, Mike, I want to read verbatim what the holding actually was.
Please.
Okay. So for determining whether or not they were citizens, whether the child was a citizen, whether a child born in the United States of parents of Chinese descent, who at the time of his birth are subjects of the Emperor of China, so notwithstanding the fact that they don't owe total allegiance to this country, but have a permanent domicile and residence in the United States and are there carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China, becomes at the time of his birth a citizen of the United States. For the reasons above stated, this court is of opinion that the question must be answered in the affirmative, order affirmed, that is to say, the child is a citizen. Now again, I know, Mike, you've had some criticism of Attorney Sauer in defense of Mr. Trump's EOs.
A.G. Sauer, who argued this case in front of the Supreme Court on Trump's behalf.
Right. But what he kept saying was, we don't think that this case applies to our situation. We think it's an outlier. But if the court does agree that Wong Kim Ark is a valid case, then the whole basis for granting citizenship in that case had nothing to do with anybody who was here temporarily or illegally. Neither one of those situations. Those are the situations that Trump says they do not qualify for citizenship. In the Wong Kim Ark case, they agree with Trump in a sense that they were here legally, they were permanent legal residents, green card holders, and they were domiciles. They had been here, as far as we know, most of their adult life. And therefore, it should not have been relied on, because Wong Kim Ark does not stand for the proposition or the conclusion that this case, the majority of the people who wrote the decision are using it as authority for their position, and it doesn't stand for that proposition.
I think that Justice Thomas is either listening to the show or read your book, because the language that you just used is the exact same language he used from his dissent. He argues that Wong's parents, and this is a bullet points from his dissent, lawfully present, permanent residents, and domiciled in the United States. And that's why he believes that it's not analogous, that the Wong Kim Ark case and the Wong specifically is not analogous. And he also says that the majority here failed to account for allegiance-based limitations, ignored the Civil Rights Act's narrow definition, which you just cited last segment, and relied too heavily on English common law, something we talked about extensively in the previous show, because, I mean, it's pretty obvious that 75 years after we just threw the king out of the country,
yes,
that we would reject certain pieces of common law as well. So I think that Justice Thomas and your points are very well made, because we like Justice Thomas, and
we do.
They sound very correct.
And we don't want him to quit.
No, we don't. Stay on that court as long as you can. Keep driving that RV too. All right, stick around, you guys. We'll be right back, wrapping things up. Things flew by this show, so we're going to wrap things up right at the break, after the break, and talk more about this birthright citizenship case. Stay with us.
Individuals and businesses with tax problems, listen carefully. Do you feel like you're losing control of your finances? If you owe over $10,000 in back taxes or have unfiled tax returns, we can help you take back control. The IRS is the largest and most aggressive collection agency in the world, and they can seize your bank accounts, garnish your paycheck, close your business, and file criminal charges. Take control of your tax problem now by calling the experts at U.S. Tax Shield, and take advantage of the Fresh Start program and new laws clause that may allow us to negotiate a settlement for the lowest amount possible. Our team of tax attorneys and enrolled agents can stop collections and get you protected so you can take control of your financial future. U.S. Tax Shield offers a price protection guaranteed quote to get you protected today. U.S. Tax Shield is A+ rated with the Better Business Bureau, so call now. 800-351-8614. That's 800-351-8614. U.S. Tax Shield. 800-351-8614.
Come visit a relaxed, family-friendly restaurant for American Eats, an on-site bakery, and comfortable atmosphere. It's the Hill Street Cafe in Burbank, California at 3301 North Glen Oaks Boulevard. Open 7 days a week from 8 a.m. to 3 p.m. Sunday through Wednesday and 8 a.m. to 9 p.m. Thursday through Saturday. Enjoy all-day breakfast from eggs, omelets, breakfast bowls, biscuits, pancakes, waffles, burritos, and more. At lunch and dinner, devour burgers, sandwiches, salads, wraps, tostadas, fajitas, enchiladas, quesadillas, chicken, pork, steaks, turkey, fish and chips, and pastas to adore. And ask about our daily specials and senior dinners, too, plus our beer and wine bar. You can also order online with delivery, too. It's all at the Hill Street Cafe. Call 818-845-0046 or go to hillstreetcafeonline.com. That's hillstreetcafeonline.com.
It's National Small Business Week, and the smaller the business, perhaps the bigger the opportunity when it comes to worker engagement. ADP Research's recent Today at Work issue reveals that just 13% of U.S. employees at businesses with less than 10 employees reported full engagement, compared to 27% of those with 10 to 49 employees. The good news? The smallest firms may have an advantage on boosting engagement. Across all businesses, 53% of workers reported being fully engaged when they strongly believed their employer was investing in them. ADP's SVP of Small Business Services, Lacey Bazzelli.
Worker engagement is a priority for all businesses. At the smallest companies, it is typical for employees to wear many hats and develop skills across a variety of functions. Small business owners can lean into this reality and help their employees develop a broad skill set that prepares them for the future of work while lifting engagement. ADP supports over 900,000 small businesses, and we hear stories all the time of their unique paths and the opportunities they have to offer.
For more small business tips, visit adp.com/gritandwisdom. Sponsored by ADP.
All right, we might have to do actually part 3 next week, but we shall see. It's this is just so much to digest and so much to interpret about this case, Trump v. Barbara, the birthright citizenship case, a case that we were looking to for a while. And just a reminder that President Trump did file for a rehearing. Everybody's like, oh, he's crazy. You can't do that. Yes, you can. It's Rule 44 of the Federal Rules of Procedure.
Very good, Mike, yes.
Where you can ask the court, you got 25 days to ask the court to rehear this. Also, there's certain things that, like going from Kavanaugh's quote unquote, like it was like a concurrence/dissent, that he didn't even say you needed to address these questions constitutionally. That it says there's a statute regarding birthright citizenship,
correct,
and Congress can amend that. And then there's also been a lot of scholarship too that perhaps a constitutional amendment you need to do to change the 14th Amendment. However, there's been some debate on whether actually you can use Section 5 of the 14th Amendment to alter birthright citizenship.
And I know that was part of the argument because the people representing the respondents, if you will, that attorney said Congress could not do anything. Well, I can't see how she can say that when it's part of the Constitution. Maybe she didn't notice that. But Congress can do it under the 14th Amendment, Section 5. Okay, in any event, this is one of the part of the conclusion by Justice Alito, who, of course, wrote the most compelling dissent. And he says this court's interpretation, now he's talking about the majority of the court saying that Trump's EO was unconstitutional. He is saying that the court's interpretation saddles this country with an ancient British rule that even the United Kingdom has abandoned, as have other countries whose legal systems share the same pedigree. So he's saying even England has outgrown this backward idea of sui soli, meaning that whoever owns the land, if you happen to step on it, baby, you are owned by that landowner. That is passé. It's already been debunked by our Declaration of Independence under my boy Thomas Jefferson, and therefore, even though England doesn't follow it anymore, we are now saddled with it, which is, of course, ridiculous.
Absolutely. Just real fast as an aside, I heard a funny line about our friend TJ.
Yes.
President Kennedy was in the White House, and he had every living Nobel Prize winner at the White House.
Yes.
And he says that this is the greatest collection of minds and of talents and intellect we've had in the White House since Thomas Jefferson dined alone.
Oh, wow.
That's a great line, right?
It is, since he dined alone.
Yeah, and so, TJ definitely a friend of the show. And you summed it up fantastically to end things here. And Alito's dissent, I think, is the most compelling because it's cuts to it quickest. And he pretty much says something that we've talked about here, and also one of the cruxes of your book.
Yes.
How this should not be decided by 9 justices sitting high up on robes. That citizenship policy should be led to the people through Congress, the representatives.
Absolutely. And of course, the Constitution says just that. Instead of having to amend the Constitution to amend an amendment, meaning the 14th Amendment, Congress was smart enough to say of Section 5, we can just pass laws, but Congress can do it, and they can amend, if you will, the 14th Amendment, which, of course, is what hopefully they'll do, unless Trump is successful in this review that they did input within the 25 days.
Yeah. So we will be watching that moving forward. And thank you for spending some time with us. Richard, a true tour de force today. Really appreciate it. And we'll see you guys next week in the Legal Lounge. Any questions, comments, or concerns, you can hit us up on Facebook.
And I'm looking forward to a coup d'etat.
All right. Hopefully the FBI is not listening. All right, you guys, stick around. We'll see you guys next week. Thank you for joining us. As always, check out Richard's fantastic book, America: An Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. Check out complete archives available on Rumble and on Facebook and on YouTube. Search for CRN Digital Talk on both those platforms. And we'll see you guys next week in the Legal Lounge.